Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. The 10th Circuit determined that the willful and wanton destruction of a person's home by police officers was an exercise of police power and not a taking requiring compensation under the Constitution. In Lech v. Greenwood et al., the 10th Circuit Court of Appeals held an opinion that the court itself says has no precedential value, that the police have no restraints on their behavior as long as the police can pretend that some exercise of police power could be argued. Now, the Lech sued under the Takings Clause, and that may have been a mistake. The court ruled that the government did not take the house. The police merely destroyed it. There is an argument that the exercise of police power should be reasonable. But let's take a moment and talk about the facts of the case. The incident occurred in June 2015 in Greenwood Village, Colorado. An armed shoplifting suspect fleeing the police holed up inside a home where John Lech was living with his girlfriend and her 9-year-old son. The boy was at home at the time, but he escaped after the suspect entered the house. Police negotiated with the suspect for about 5 hours after he fired a shot that struck a police car. When negotiations failed, the police fired several rounds of gas into the home, breached the front doors with an armored vehicle, sent in a robot, and used explosives to create points of entry to the home. A tactical team tried to enter the home, but the suspect, Robert Seacat, fired at officers again. Police once again employed the armored vehicle to open up multiple holes in the home. This time, the tactical team was able to arrest Seacat. The home had to be demolished. The city of Greenwood Village offered to help with temporary living expenses while the home was rebuilt, but refused to provide any other compensation. They offered $5,000, by the way. State courts in Texas and Minnesota have sided with innocent homeowners over the police. However, those were state court decisions under state law, which might be better than federal law for the citizens. The court defining the taking extremely narrowly in this case, essentially only eminent domain. And of course, the court's position is ridiculous. This comes back to something I've said before and surely will say again. Legal and right are very rarely found in the same place. My focus on this case is not in the takings clause, but rather the police power argument that the court used. The reason I don't focus on takings clause is because there is precedent that this was not a taking. However, the incident was reckless, willful, and a negligent exercise of police power. Police officers have an obligation to exercise that power appropriately. I cannot for the life of me think of a situation where driving a tank through a building in pursuit of a shoplifter is appropriate. There is no way to explain this that makes the police officers less culpable. They drove an armored Bearcat, a vehicle designed for military use, into a building. Not once, not twice, not merely 3 times, but at least 4 times to punch holes in the building in pursuit of a shoplifter from Walmart. Think about that. The police drove an armored personnel carrier through a building at least 4 times in pursuit of a shoplifter. What the hell would they have done if he had committed a more serious crime? Execute the property owner too? When negotiations failed, the police started an assault on the home. The officers breached the door with an armored vehicle. They used explosives to blast holes in the walls. They flung tear gas canisters inside and fired 40mm rounds at the house. For those that don't know, 40mm rounds are grenades fired by either an M79 grenade launcher or an M203, which is typically fitted under an M16. You probably saw those in old Vietnam War movies. The Army still uses the M203 and an automatic grenade launcher called the Mark 19. So in addition to the more than $580,000 in damage police caused at Lech's home, they also caused more than $70,000 in damage to a neighbor's home. The exercise of police power must be reasonable. It is not reasonable to burn down the house in order to drive the suspect out. It is not reasonable to drive armored vehicles through a home to chase a shoplifter. It is not reasonable to fire hundreds of rounds of ammunition at a shoplifter. And I will admit, at this point, this is where some pro-cop crowd can get some traction. Apparently the shoplifter did fire a couple of shots at police officers. But if the police officers followed basic tenets of firearm safety and only fired when they had a target, they would have killed the shoplifter with fewer than 20 rounds fired, assuming their aim sucks as badly as their reasoning abilities. So I think the court got this wrong, but it may not be just the court's fault. The argument probably should have been on the gross negligence of the application of police power. Please hit like and subscribe. We're going to follow up on this case if it is appealed to the Supreme Court. Thank you for joining us.